Hey everybody, how you doing? I'm Leonard French, your favorite copyright attorney, and I just thought I would take some time today to go over the status of the h3h3 lawsuit, which is sort of moving along, but maybe slower than most of you might think. You may remember back in, I think it was April, Matt Hosinovich, whatever his name is, filed a lawsuit against Gila and Ethan Klein of h3h3 Productions fame. Alleging that they had committed copyright infringement by using one of his videos in one of theirs. So I thought that I would go through this today with you. And so here's the website. What we use is the Public Access to Court Electronic Records. It's called PACER. Once you log into the correct district court system, in this case you can see I'm in the Southern District of New York, you're greeted with this kind of weird interface. You need to make a query up in the upper left here, and then type in the case number or find the case number by typing in a name or something here. So yes, it's Matt Hoss is what we're going to call him, versus Klein et al., and it's before Judge Catherine Forrest. Judge Forrest is not a judge to be toyed with. This is her. Born in New York, grew up in Connecticut, one of 6 children. Law firm in 1990, partner in 98. Nominated by President Obama in 2011. She was part of Hedges v. Obama, enforcement of the National Defense Authorization Act, infinite detention. Let's see. She dismissed a price-fixing lawsuit against Goldman Sachs, JP Morgan Chase, and Glencoe. And, this was yes, I forgot about this part. Yes, she was the Ross Ulbricht verdict. He was the Silk Road drug dealer. Yeah, she ruled that emoji are permissible court evidence. Then she was doxxed. Anyway, so that's Judge Forrest in this case. We click on Docket Report over here, and this will give us a good example of what's going on right now. This was filed on April 26th of 2016. It is a copyright infringement case. The plaintiff is Matt Hoss, and he is represented by Tim Booker and Michael Feldberg of Thompson Booker LLP in New York. Nothing that we didn't really know before, but that's who they are. The defendants are Ethan and Gila Klein, and as we know, they are represented by Walter Michael Lee. I think he just goes by Michael Lee, of Morrison and Lee from the video game attorney fame. The way these things work is there's a number of things the plaintiff has to do at first, especially in a copyright case. So here you have the complaint, and if we click on this, it'll actually bring up the complaint. You'll have to pay for that, though, 10 cents a page. The summons are the official service of process in a lawsuit like this. Just about any lawsuit has to follow the laws of due process, the legal procedure that you are due, that is due to you, in order to say that we have completed some kind of notification to you, and you have an opportunity to respond, a meritorious or a reasonable opportunity to respond before an impartial judge or impartial tribunal, as they'll say. So then the case gets open, the magistrate gets assigned. A magistrate judge, Deborah Freeman, is usually assigned to cases to handle things for the judge and then make a recommendation to the judge. And you may see some of that here. I don't know, I haven't looked. But sometimes the magistrate judge will make a recommendation to the presiding judge in order to achieve some kind of efficiency, take some of the caseload off of the presiding judge. You'll see this a lot when a certain kind of lawsuit is filed a lot. Some of the cases I represent in, same case is filed over and over again, so the court will assign one judge to look at all those cases and get good at all those cases rather than have each and every judge look at those cases over and over and over again. So back in the end of April, we already have our first amended complaint. I'm not going to really go into what they amended. They probably just corrected an error or something that was noticed when they filed. And then the judge set a pretrial conference for June 16th. So at this point, at the end of April, nothing happens with the lawsuit until the plaintiff serves the defendants. And by service, I mean that service of process, that due process that I was just talking about, which is just a weird legal term for handing you the papers and having a person available to testify that you were given the papers. That person is called a process server, and that's the thing that you see online or on TV when someone hands somebody something, and says, "You've been served." It's sort of like that. Most of the time, it's just, "Here's your legal papers. Please confirm your name," that sort of thing. Sometimes a process server has to go to extra lengths to catch somebody who's avoiding receiving the papers, who might literally run the other way when they see the papers coming, might somehow otherwise interfere. And so sometimes you'll see a process server in real life dress up as a delivery man or something to fool the person into giving their identity and accepting the service of process. That doesn't work out as well in real life as you might think for the defendant trying to avoid the process. I have personally successfully served people well outside of the rules of service of process, only because I was also able to testify to a judge that they were there and they knew I was there and they knew I was trying to hand them the papers and they were avoiding me and they obviously knew there was a court case and they just didn't want to get the papers. So we got the papers to them some other way, like by mail or something like that, and testified to the judge about what happened. And the judge allowed that. So it is not, avoiding service of process is not an end-all to a case. So a lot of times you'll see a defendant will accept that service of that paper, or will even sign a form to avoid having to accept the service of that paper in public or at work or at home in front of their spouse or something like that. So nothing happens until they are served. So where is the return of service? It should be in here someplace. It's not in here. Issuance of summons issued next day. I do not see a return of service. Okay. I'm assuming someone at some point signed what's known as a waiver of service, which grants you more time to respond. And the reason why I'm assuming that this happened is there is this 4/28 date and then nothing until June. You would normally only have 21 days from the service of that, from the receipt of that complaint, in order to respond or challenge the complaint. And so that hasn't happened here. I don't see the return of service. No, the only place service comes up is on the Pacer Service Center thing on the bottom. We'll try return. No return of service. Okay, that's weird. But that may just be an oversight on someone's part who forgot to file that on the docket. They may actually have the return of service document, and just because it's not on the docket doesn't mean it's fatal to the case. It would just mean that someone made an error and forgot to put it on there. If that had not been received, I would expect the defendants to be trying to dismiss the case on those grounds, and then of course the plaintiff would try to correct then and avoid the dismissal of the case. What is this first letter motion? Writing to request an adjournment of the initial conference. So already right out the bat, right out the gate, right off the bat, there's going to be some kind of delay in the case because because someone from the defendant's firm will be out of the office. Okay. So that was adjourned. Then a motion was filed at the end of June. The motion to dismiss the complaint. That motion looks like this. Please take note. Move to dismiss. Defendants move to dismiss. Where's the rest of the motion? Okay, there's a memorandum of law, but where is it? Ah. Defendants' memorandum of law in support. So what they are doing here, when a case is filed, the defendant has several opportunities to attempt to dismiss the case. They really need to have some grounds to do so, but this is their opportunity to allege those grounds. There are many different ways. In this case, they are citing Rule 12b-6. This table of contents is kind of a good way to get an overview of what they are going to argue. They're going to argue that Matt Haas's copyright registration is invalid, and they are going to argue that because of that, there is no claim to be prosecuted under the law. That's 12b-6. So Federal Rule of Civil Procedure is what that means. So Federal Rule of Civil Procedure 12b-6. The reasons why they say the copyright registration are invalid are the way it was registered. It was registered as part of an unpublished collection, and because that video should not be able to be registered as an unpublished collection, it shouldn't have a proper copyright registration, and you can't sue without a proper copyright registration. And they cite some authorities on this, and I'm not going to go too much into this. Let's just skim through it. The unpublished collection was then published. It was part of a collection of works, yada, yada, yada. It tries to explain what defendants' videos are. They're just saying that it's misclassified, that it shouldn't have been registered that way, and because it was registered that way, it should not be a valid copyright registration, and therefore you can't sue without a valid copyright registration. That's what that means. So they filed that, and then must have had some sort of discussion. Let's see, what is this declaration? We'll just look at the declaration for now. 50 cents! I'm spending 50 cents! Hereby declares under penalty of perjury, let's make this bigger. Resident, State of California, yada yada, filmmaker, online streaming, yada yada yada. I do own the copyright. I initially sought to register the collection as published works. The U.S. Copyright Office wanted me to register it otherwise, is what he says. And they copied my video. I issued a takedown notice. We were unable to reach an agreement to settle the matter, so I proceeded to file this action. They responded by saying they were being sued. Sorry, am I being too dramatic? Okay, so this is just more of the same. More of the same that we've seen, that you copied my video. That's it. It's just dramatic ways of saying copied my video. And I do own a copyright registration. So then the parties must have discussed all of this at some point, and they filed another one of those letter motions. Where'd it go? On the 21st. Okay, they had a pretrial conference. Initial report of the parties. Let's see what this says. The parties do not consent to conducting the matter before a magistrate judge. We really want to see Judge Forrest on this one. I'm going to tell you how that conference went. I wasn't there. I'm not, this is my opinion. This is my guess, my opinion. When the last time I saw a judge like on something like this, the conversation was very much steered in the direction of settling the case or adjudicating only the actual individual meritorious issues at law. So really in this case, it's going to be, was there a fair use of Matt Haas's material, or was it copyright infringement? That should really be the only issue, right, guys? But we really haven't talked about that much here yet. We've just said, oh, your copyright registration's invalid. No, it isn't. Yes, it is. Okay, well, we'll settle that later. That's really all that's happened, and it's been 4 months. More than 4 months now. So eventually, the parties met with Judge Forrest, and I guess they came up with this. This was the conversion of that motion to dismiss, which happens in the beginning of a case, into a motion for summary judgment, which usually happens towards the end of a case. A motion for summary judgment really can come almost at any time, but there has to be enough evidence on the record to support a judge making a conclusion that the case can be determined at that time and that there are no genuine issues for the case to go forward. So this is the agreement that the parties, both Matt Haas and the clients, h3h3, came to, that says we're going to deal with that part later, that the plaintiff can amend its pleading yet again, and that defendants shall respond to the second amended complaint, which I believe they then did. And then there's a second amended complaint, which is going to rehash everything. Then there's an answer to that second amended complaint, which is probably going to look very much like the previous one. And that's where we're left, is there's nothing happening at the moment until the parties complete discovery. And you won't see anything on here about discovery until there's a dispute over discovery, because the federal rules of civil procedure require the parties to try and work that stuff out privately first. This is not super exciting yet. There's not a whole lot here. What we really want is that opinion of a judge that says, here's why it's fair use, here's why it's not fair use, and here's how I rule. But we're not going to get Judge Forrest to even really look at this case terribly much until there is a complete docket, until this page here, basically, this is the docket, until this docket is a record of all the things happening in the court case, until that record is fully complete with all the evidence of what's in the video and what's not in the video, how it was created, was it created specifically as a way to copy Matt Haas's video, or was it created as a way to comment on Matt Haas's video? Does the commercial nature of YouTube and having a channel on YouTube monetized, does that change whether the use of the video is fair use or not? These are all things that we're looking forward to hearing, but we haven't been able to discuss any of this yet because the parties are still fighting over the, frankly, normal stuff they're supposed to be fighting over, which is trying to get the case dismissed, if you can, trying to weaken the plaintiff's case before the thing even gets started, if you can. Ultimately, what's happening here is whittling down the issues to something much finer a point that the judge can look at and decide which side of the line that point should go on. So thank you for watching. I will post another update on this case when there's more to update. We haven't seen anything for about 3 weeks now, so discovery can take weeks to months to years, so we need to just wait to find out what's going to happen next. I'm not involved in the suit in any way, and I couldn't comment on it if I was. So that's that. Let me know what you think of the whole thing, and I'll be happy to give you my thoughts in the comments as well in response. Thank you for watching. My next video will be on YouTube's content policy update. Expect that to be around Monday sometime. I should have some time on Monday to get that up. And then from there, I'm going to try to do my prosecutorial discretion video for the following Monday. So thank you very much for watching. I'm Leonard French, and have a great Friday. Okay, hey everybody. How you doing? I gotta remember you're over here now. I don't know if I touch that, that's gonna refocus. Let's not do that.